Ladies and gentlemen, allow me to start our next session. It will be a panel discussion on a theme Preventive Restructuring Frameworks, New Horizons. Let me introduce Jiří Tomola of DENTONS, who will be the chair of the panel, and Jiří will introduce his panelists.
Okay. Ladies and gentlemen, we are switching to English because we have a guest from the abroad. I will start from the far right. Daniel Fritz, he's a partner in our DENTONS Frankfurt office and one of the leading experts in insolvency in Germany. And next to him, you all know Tomáš Richter. Next to Tomáš, Nora Wouters, partner from DENTONS Brussels office. And all these three experts have been members of expert team attached to the commission who has been working long years on a draft directive we are talking about. Bohumil Havel, counsel in PRK and leading Czech insolvency expert, and next to me, Rainer Frank, counsel from KHB, and also person deeply involved in insolvency. So let's start our panel discussion. I would now pass the word to our three experts because I think it's fair to start from the very beginning. What was behind the directive? What were the original ideas? And what happened that it ended as we see it now?
What was behind the directive is we have to take it back to the Union Action Plan, where the idea was that we needed to have a sort of harmonization in Europe to assure that viable businesses could be rescued, that employment could be saved, and that capital could flow from one country to another without obstacles being put in place by inefficient restructuring systems and legislation. And that was the initial idea. The banking union added an additional condition to that. They said it was immediately after the financial crisis. Lots of countries had banks with huge piles of non-performing loans. And we wanted to assure that we had systems in place, at least minimum conditions in every country, that countries would be able to handle these non-performing loans, specifically looking at Greece or Italy or Spain. And that was the initial thought. So when we were drafting the directive in our working group, I think we had a clear line and a plan. And maybe it was a little bit too much depth-driven, but there was a system, a line in it which you could follow from the beginning to the end. We had the idea of to who it would be applying, what we wanted to achieve as a minimum requirement, out of court or under the supervision of a court, and we wanted to make sure that people who have failed down the road, they would be allowed a second chance, like in the US, where you don't have this stigma if you have been bankrupt before. That was the idea. Now, looking at the second largest version of the directive, I got a little bit disappointed when I saw all the compromises which needed to be taken. And this related to when do you open, what sort of companies do you allow for such a restructuring, what do you consider with being a viable business or not, do you need to have an expert coming in, what about the stay, is it a general stay, is it a partial stay? What about classes of creditors? Do you allow them or do you ask for them to be mandatory? What about cram down, cross cram down? And if I look at the current version, it looks like an a la carte system where you see that you can either install a creditors-driven system or you go for a debtors-driven system. Some may take into account equity shareholders, other ones say, look, you know, out of the money, you're no longer being heard. There are so many options available that the idea of having an harmonized system, which was also the idea to allow for free flow of capital, it's far away. And I think what this current draft is doing is opening the door for a lot of forum shopping. And we were talking about a baby earlier. I'm a little bit disappointed about the baby, which is now on the table.
So I totally agree with you, Nora. Maybe 3 additional aspects to that when you ask me historically where this comes all from. The original goal of the old commission, led by Viviane Reding that time, was that she was observing as a result of our work on the European insolvency regulation that SMEs across Europe are suffering from the missing laws on easy restructuring outside insolvency. So this was the general observation of the old commission, and the idea was to put something in place that could help for easy and fast-track restructuring, in particular for small and medium-sized companies. That was the idea. And then came the current Juncker Commission, and I was still impressed by some pictures they were showing us, basically not pictures but graphs about the development of the NPLs. As you mentioned them, we saw that the US, they had all the big housing crises in the aftermath of Lehman, but in the end they resolved the NPLs, whereas Europe is still, as of today, sitting on toxic NPLs. And as we have this toxic situation, which is now also a high risk for states like Italy, which nearly bankrupt now, the only remedy we have is a drug, and the drug is the zero interest policy of the European Central Bank. And it is clear for the Commission, at least, that we cannot live forever on a zero interest rate drug in our business environment, and that we really need to do something to higher the interest rate. We may face also recession now, and we need to do something for the NPLs. And so the idea was here again, and this was referred to the capital markets, to put something in place, in particular in these jurisdictions where insolvency take months and years and years and years, and there's no outcome, to have a quicker resolution for that debt. So there is a correlation across Europe that the high NPL rate is be seen in particular in those countries where the insolvency regimes are not efficient. Because if the insolvency regime is not efficient, people do not buy NPLs because there is no exit for the NPL.
Can I just add 2 observations, Jiří? I agree with all of that. I just think there were political economic elements in that that go beyond that, and they could be labeled insolvency tourism. What happened quite quickly after the European insolvency regulation, the first one took effect in 2002 in the old member states, and which took effect here 15 years ago when this country acceded, was that it became pretty clear pretty soon that there are vast differences between substantive regimes of discharge of debt across the Union, and that led to people migrating strategically from one Union member state to the other in circumstances where the social costs of that are sort of reasonably manageable. So between France and Germany, close to the border, et cetera, there was arbitrage between the differences in those systems. The Commission took notice, and they started a process of evaluation of regimes of discharge of entrepreneur debt. And that was going on, I suppose, as early as 2005. At that time, it was DG marked. It wasn't DG Justice. But that gave an impetus to DG Justice when they later started to look at this, to really start to think about the second chance element of what we now have as the discharge of entrepreneur individuals, if you will, in the directive. So that's one part of migration that have an imprint on this, and the other part was corporate migration. I mean, again, it became very clear after the EIR was introduced that large companies who have the money and the resources to shop around the union for legal regime were doing that. And at a certain point, I think certain large member states, including Germany, including France, including Spain, realized that a lot of their companies strategically migrate to England to deal with their debt there. And rather than being happy about it so that their courts don't have to deal with it, they get annoyed. And they thought, what can we do to actually provide our companies with similar instruments back at home? And that, I think, is basically how the entire preventive restructuring thing came around, or it is one way of looking at it.
Okay, so this was the background. I hear the disappointment of the parents a bit. So what can we do about this? We now have preventive restructuring framework, and will it be a tool for really proactive solution of financial difficulties, or another battlefield between the creditors and the debtors? What do you think?
Thank you. I see also the parental disappointment, but maybe I can add few positive remarks that I see in the documents. First of all, the theme of this conference is insolvency. But I don't think that we are living now in the world of directive and background of insolvency, because main parts what I understood are about private law negotiation, about corporate law negotiation, about fiduciary law and the specification of fiduciary law and fiduciary duties, and maybe about litigation in the end of the process. And after that, we can talk about formal insolvency procedure. So from some functional approach, I can see many of good ideas which can improve national regimes in area of private law, in area of corporate law, and mainly in when we are trying to motivate all the debtors, all the statutory bodies and so on for acting quickly, not in the time of insolvency. So from this point of view, I can see that the directive has few good ideas, and the texture of the directive is open. So we can find many of solutions to achieve the aim of the recitals of the directive as a whole. So that's first, I think, good message for me, because I'm from the auditor, I'm not the parent, so I can see only the text and read the text. And second point is about the cost, because of course, if we will have regulation of this rescue process, regulation of insolvency process, regulation of something between, it can maybe higher the cost, but maybe if the rescue corporate process will be functioning, maybe the rest of the debtors, which will go through the formal process, will be lower. So maybe the costs will move to the negotiation, to the private negotiation, and it's up to the Czech law, up to the Czech regulation of motivation to say to the debtors that they should, not only may, but they should file into the informal process as soon as possible. And maybe that's the reason why in the beginning of this session I was talking about the specific law, not about the amendment of insolvency law, because insolvency law is the end of the process. Maybe we can move our thinking to the first part of the process, to the time of distress or before the distress, not only in time of distress.
Okay, so I would like to react to two things I heard so far. The first is that this is not insolvency, but something before insolvency. I totally agree. And what I think is we have basically three things. We have likelihood of insolvency. When we have now preventive restructuring, we have kind of threatening insolvency, which is already real insolvency, for example, in Czech or German law. And then, of course, we have insolvency. And what I think is there must be a clear distinction between likelihood of insolvency and this preventive thing, and then threatening insolvency. And that's not easy to do. And in my opinion, it should be done rather in a new law and not somehow meddling into insolvency, which reasonably works. And the distinction line for me would be as soon as a company is not able to pay its dues when they fall due, then there is a threat of insolvency to some kind. And if they're not that sick, then there's room for preventive insolvency. That's something to discuss, but at some point in time, there should be a clear distinction, because otherwise it gets fuzzy and you don't know which law to apply. And the second interesting thing was about these non-performing loans, and that it's the aim of the directive to reduce the number of non-performing loans. And there I think the directive does not really react to banking regulation, because when I have the moratorium, as foreseen in the directive, maybe the collateral of the bank is not worth as much as before, and then banking regulation kicks in, and the bank may have to build reserves or do whatever. And then in the US, for example, from what I know, banks then rather, and where they have this preventive restructuring, banks then tend to sell their loans to hedge funds. And then these hedge funds, of course, are much more terrible to the debtors than the nice banks they are used before. So instead of reducing the number of non-performing loans, this may end up essentially in increasing the number of non-performing loans. So these are my two reactions from what I've heard.
Well, some views optimistic, some less. Tomáš in his previous presentation raised many questions about implementation, about
Which you guys
issues.
couldn't understand.
Yeah. But this brings me to another question, and it's to you, Nora and Daniel. Can you just tell us what are your views, and if you have in your respective countries, Germany, Belgium, any mechanism that resemble preemptive restructuring, so on?
Yes, as I mentioned yesterday already, since 2009, we have, it's called the law on the continuity of enterprises. We call it the Belgium Chapter 11. This law has been in place for 10 years, so we have a good view. And I have to say that I've seen much less bankruptcies than before. And briefly, what this law provides is you have a negotiation stage, which was a debtor runs into problems with a few creditors. It can be a bank, it can be major suppliers, and he makes an agreement with that creditor. It's an agreement which is confidential. You file it with the court, and it remains there. And later on, if the debtor is not successful and there's a bankruptcy, this arrangement is protected. And last year we got some changes to this 2009 law, because we saw that this system that we had in place, totally on a contractual basis, was not fully what we intended it to be, because new financing was not protected under that system. It was only the parties in the agreement. So we added a clause and provided that new financing would be protected. This is already ahead of the directive, because Belgium didn't wait for this proposal. We just made the changes which we thought necessary compared to the legislation which was coming, and compared to our neighboring countries like France, where they have a lot of out-of-court restructurings. We have another possibility, which is more a collective arrangement, which provides for a stay, and it involves much more parties. It can also provide for a transfer of the business. The stay is for the moment 6 months, but under the directive it should go, the first stay should be 4 months. It has been very successful in allowing companies to restructure, and yeah, I can say that it's certainly beneficial. It provides how the plans should look like. It provides for you are not obliged to have classes of share of creditors, but of course there's always a difference between the priority, the privileged creditors, and so on. The cram down is allowed, but you should not, at least the priority creditor should have 20% of their claim. And so we have a system in place, and I can recommend, because if you look at the statistics, what we see now compared to 10 years before, it has been a positive evolution. Yep.
What is the position of shareholders in this process?
It depends on the situation. So in principle, it's, if there's something left, then of course they get something, but it's like the voting, it's mainly concerns the creditors. And yeah, if the shareholder is out of the money, of course, there's nothing to be distributed.
Thank you, Nora.
So, thank you. If you ask me about the situation in Germany, one legal term of the new draft regulation is paramount and very decisive. This is the term of likelihood of insolvency. This is the parting point between insolvency and out-of-court restructuring. In Germany, we have the insolvency reasons of illiquidity. So if you're illiquid, if you're not able to pay the debts as you felt due, as mentioned before, you have to go to a normal insolvency proceeding. However, if you are in a stage where there is a threat, and it's more than likely that you will become illiquid, you can go to use insolvency risk restructuring tool, and in particular now with new law, you can do it in a debtor in possession proceeding. So if you file late, you need to go to a normal proceeding that's abbreviated and in a nutshell, and if you file earlier, you can go. And the problem is always for the restructuring world, if a managing director is coming to a lawyer and say, I have a problem, then it's like looking into a crystal ball. Because you can only continue with the business if it's more than likely that it will not become illiquid. And you need to make a forecast for the actual year and the next year. And then you have always good reasons to say, oh yes, we will work on a turnaround, we will have more customers whatsoever, and therefore it's more than likely that we will not become illiquid. But if you then actually become illiquid in the next year, the insolvency administrator will sue the director and will sue the councils and say, as a hindsight bias, view, yes, you should have known better in the past. And therefore, it is among restructuring professionals really much welcomed that if in this gray zone where the insolvency is likely and nobody really can predict if it's more than likely or more than unlikely, we have such a tool in place where we can act under a law in a legal way. And so maybe you can guessed it already from what I have said. We have no restructuring law yet in Germany. We have a quite sophisticated system of restructuring guided by precedent law of our Supreme Court. And in order to catch up with the problem of likelihood of insolvency, you need a lot of expert opinions. The minimum cost for such an expert opinion is 20,000 euro for a small business. And if it is a big company, the cost can be 1 million to get something, such expert opinions. And here you can see that only those who can afford such guidance can avoid insolvency. All the others need to go to insolvency. And therefore, we appreciate a situation that we can legally protect a company if they want to negotiate with the creditors, with a moratorium and all the tools of the draft directive. Another thing what was mentioned, I want to follow up, was what Bohumil Havel was saying, that it is contractual. In Germany, our Ministry of Justice, unlike the Netherlands, has not yet come up with a draft, but they're working hard on that, and they also say the directive is written in a way that countries which have dysfunctional insolvency proceeding can use this draft to introduce new type of fast-track proceedings, but also you can introduce contractual solutions. And they say the better arguments are currently speaking to use this draft directive to introduce tools and not a proceeding. That means we still have an out-of-court restructuring, that's our understanding in Germany, but if you have spoil sports, holdouts, who want to leverage nuisance value, you can use the moratorium to protect out-of-court restructuring. And the same is if you then are finally on a contractual basis cannot agree on a restructuring agreement by everybody undersigning and writing in writing, you can also go to court to force a minority under the will of the majority of the shareholders. So the whole thing is now, and may look in the future, you are a managing director, you have a problem, you go to the equity funds it, equity doesn't fund it, you go to your creditors. And if the creditors say, we don't trust you anymore, please go to the court, then you go to insolvency. If the creditors majority says, yes, there is some value in there, we are happy to take a haircut or to do some restructuring with you, close some parts of the operation, whatever, the majority is saying we want to continue with the business and there's only some nuisance value creators, you have a good way to deal with it. And this can be achieved, I think, in the best way if you use the directive to implement a toolbox approach, a contractual approach, and not a proceedings approach. This is currently also what we expect in Germany to be happen in the future.
Tomáši, I have a question to you. I mean, you post lots of questions about implementation. You see how the other countries are addressing it. Most of them are trying to stay out of court or, ease the proceedings. Isn't this the way we should take?
I think we probably should. Really, that's what my draft from 2012 that I alluded to before was all about. The idea was that the debtor would come with a deal done with a sufficient majority of the creditors, and it would all go public and would trigger a stay, even if the debtor really needed the stay, because there is somebody who is trying to torpedo the process through execution or through insolvency petition or otherwise to create holdout value. And I think that the directive still allows that, because it specifically says, and if I have one feather on my cap in that whole thing. It is this clause. It specifically says that yes, it looks at it conceptually as a plan starting with 0 and going forward, but it can also be conceptualized backwards, so the debtor files an agreement. And it only goes through the voting and everything if there is need for that, because there wasn't sufficient majority building in the out-of-court process. And I think that we really should consider that.